Our last panel for today, though, somewhat starts to get into that, and also is a nice capstone for the day because we've been referencing tobacco all day. You know, tobacco just hangs in the ether as the what not to do, or the concern that we all have if we care about abating the epidemic, if we care about saving lives. Tobacco is not what we want to happen. So for that panel, which is moderated by Professor Oliva from Seton Hall, we also have Courtney Hunter from Shatterproof. We have Professor Allan Brandt from Harvard, who wrote the book, The Cigarette Century, which discusses a lot of the lessons from tobacco. We have Michael Barnes, the chairman of the Center for U.S. Policy, and we have another expert in complex litigation and mass litigation, Professor Teddy Rave from the University of Texas at Austin. So for the last panel, Jen, I'll turn it over to you.
Thank you so much, Professor Glover, and thanks for having me today. As you just heard, we have an all-star panel, so I'm going to go ahead and let them get started. I do want to remind everybody to please put questions or comments in the Q&A, and I'll be managing that throughout the discussion. Our first speaker is Dr. Allan Brandt. He's the Amelie Moses Coss Professor of the History of Medicine and Professor of the History of Science at Harvard University. His work focuses on social and ethical aspects of health, disease, medical practices, and global health in the 20th century. I am going to turn it over to Dr. Brandt to get the discussion started.
Thanks so much. I'm just trying to share my slides. Not all that successfully, but I think I'll just go on in any event, and I have them here. So thanks so much for having me. This has just been a remarkable conference, and I couldn't help but think as I've been listening today that I wish in those years just before the MSA tobacco agreement went into effect, that people were thinking this critically and thoughtfully and concertedly about how those funds would be used. And as we've heard any number of times over the last several hours, I think one of the motivations for the discussion that we're having today is the fact that the MSA sits over public health litigation like a dark cloud. And all of us, I think, gathered in this Zoom room are really committed to a notion that as this next set of public health litigation associated with the opioid overdose epidemic comes to settlement and fruition, that these funds be used in the most efficient, effective, and appropriate ways, which, as everyone knows here, was not the case with the MSA. I should just say briefly, you know, the Master Settlement Agreement was signed in 1998. It included $206 billion to the states over 25 years. 46 of the states signed on to the agreements. 4 others had individual but similar types of settlements. And that in this instance, the funds were compensation for state Medicaid expenditures on smoking-related diseases. So just as in the last presentation by Ariella Migdal, it in some ways was backward looking because the states had tremendous Medicaid expenditures, but at the same time, it was forward looking about how to abate the future of smoking-related diseases and deaths. And the Attorney General sought unrestricted funds in order to provide flexibility to legislatures for how best to conduct that abatement. But that turned out to be an enormous problem in the way the funds were ultimately utilized. As Regina LaBelle mentioned in her fantastic keynote around lunchtime, generally less than 10% of these funds have gone to programs associated with treatment for smoking-related diseases, smoking cessation, or smoking prevention. And I think one of the things that was so disappointing and frustrating is that states use these funds for many different purposes, often to fill budget gaps. These funds were on call when there were state deficits. One state used the funds to purchase textbooks for parochial schools. Another state used them to purchase laptops for legislators. And the use of funds was often determined by external fiscal needs and budget deficits, as I mentioned, as opposed to really being directed to resolving the enormous problem of cigarette smoking, which even today leads to the death of about 500,000 Americans a year, even though smoking rates have declined so substantially. There were other problems with the mass settlement agreement. Many states securitized those funds in order to accumulate more monies up front. Bonds were issued. And perhaps one of the most painful ironies of the MSA was that the tobacco companies raised the price of cigarettes. And so the people who actually paid for the settlement were not so much the companies themselves as a regressive tax on existing smokers who were addicted to nicotine. And so there's so many dimensions of this. And I think all of us who have been watching the opioid settlements are incredibly eager to try to avoid what happened with tobacco. There's been a lot of research on what went wrong, especially among academic economists. Frank Sloan's group at Duke has written an extensive number of papers. And they conclude, and there's a good deal of consensus about this, that voter preferences and constituent interests about the use of these funds were unclear and largely unknown. And that's obviously an issue that's been addressed explicitly today. But further, governors and legislators assume discretion for the use of these funds. They decided to support existing needs and prioritize that over new and innovative approaches. And it also became clear that funding tended to be shaped by prior or pre-existing commitments, which is a well-known aspect of the political science of budgets. And so these unrestricted funds tended to be used for short-term political benefit, as opposed to really addressing the essential health problems from which they had really been derived. And so as we look at this, public health advocates, and Professor Glover made this point at the outset of today's meeting, have often turned to litigation, especially in instances where political approaches have failed and regulatory approaches have failed, both of which have been essentially true of our opioid crisis. And without earmarks for compensation, the MSA, I think, in retrospect, was sure to actually fail, and that legislators had the opportunity to look at these funds as a windfall. A kind of cookie jar is often the metaphor that gets used. And they had no predetermined allocations, and the funds were essentially irresistible to lawmakers. So what are the lessons really that we can try to take in hand as we think about the development and the beginning of the flow of settlements in the opioid cases? And I think they're really this, and it's especially true, I think, with people who have suffered from substance use disorders, is that treatment and care generally have weak political constituencies and support, that opioid use disorders and other substance use disorders remain so highly stigmatized. And so in terms of their political cachet, we still, as a culture and a society and a polity, tend to blame people who have used addictive substances, as opposed to looking at the broader structural, social determinants of opioid use and problems of addiction. We also, I think, tend to stigmatize the essential harm reduction strategies, which are essential to the well-being of affected individuals and groups. And substance use disorders, their treatment and prevention have typically been among the lowest priority items, despite the ongoing epidemic of overdose deaths. And as many have pointed out, they are often marginalized from our typical healthcare systems. From a public health standpoint and from a public standpoint, there's considerable misinformation, tremendous stigma, and inadequate education about safe and effective treatments for substance use disorders. And typically, there are multiple regulatory and access barriers that we've heard so much about today. And it really speaks to the need that's been articulated so well for patient-centered services, training, better insurance opportunities, regulatory relief, treatment programs, and especially attention to co-occurring conditions. So I've been asking the question, what will be required to avoid the MSA outcome? And what are the lessons from MSA and the political and cultural aspects of substance use disorders for the effective use of these funds that will be secured through the litigation? And obviously, model laws has been one issue that has come up in this context. I think they're critical, but I think we also know that there will be considerable political debate about how those laws are structured, especially in red states. We have to think about effective use of the funds I think that effective use of the funds will be dependent on intensive advocacy, activism, and oversight, and the participation of key and diverse constituencies. And obviously, that's already been emphasized during today's discussion. But I do think that, as I look back to the role that activism has played in public health successes over the last 3 or 4 decades, there's no question that there has to be the notion that there are people attending to this in a public and political realm. And here I would say the disposition of the documents in litigation has been a crucial source for activism. And even when tobacco cases were often losing, the accrual of documents that were so incriminating, I think really had the impact of reversing the notion of blaming victims to attending to the forces that had really produced the tobacco epidemic. And I'm hopeful that that will be the case with the deaths associated with opioid use. Obviously, how the funds get utilized has important implication for those who have been harmed by the aggressive and deliberate intentional promotion of addictive products, as well as many have emphasized for the future of health equity for affected individuals and populations. So I think in the end, establishing clear and transparent mechanisms of accountability and having political consequences associated with that accountability will be critical. So I'm sort of hopeful as a historian that we can utilize what we can come to understand about the MSA and its failures in order to find sort of new and innovative approaches to assure that these monies don't get squandered in the way that they were from the MSA. So I'll stop there, but thank you very much. Look forward to taking questions.
Thank you so much, Dr. Brandt. Next up, we have Professor Teddy Rave. He's a professor of law at the University of Texas School of Law, where he writes and teaches in the areas of civil procedure, complex litigation, constitutional law, and election law. Professor Rave, I'm going to turn it over to you now.
Thanks so much, and it's a real privilege to be here and to go after Professor Brandt, and thanks to everyone for organizing and including me. So the experience with the tobacco settlement that Professor Brandt just told us about created a real level of distrust of the state attorneys general on the part of many localities. And as a result, many cities and counties and other political subdivisions who suffered real costs from the opioid epidemic went out and hired private lawyers to bring opioid claims. And most of these claims were consolidated in the MDL and in front of Judge Polster, with some in state court and state consolidations as well. But once we have all these subdivisions in the mix, a 50-state agreement among the state attorneys general, like the master settlement agreement, can't really work to bring closure. We need to find some way to resolve the claims by the localities as well. And that problem is complicated by the fact that not every subdivision sued. So not only do we need to find some way to settle with the states and the thousands of localities who have sued, but we also need to reach some sort of resolution with the tens of thousands of subdivisions that haven't sued, but could sue in the future. So shelling out a whole lot of money in a global settlement doesn't look very attractive to the defendant if they're going to keep getting sued in cases that can produce $100 million verdicts. And it looks even worse if the lawyers for the settling subdivisions are going to take the money that they made in fees on the early settlements and then invest that in bringing new litigation on behalf of new subdivisions. And this is the problem that the negotiation class, which we heard about this morning, was aimed at solving. So the idea there was to create a class of all subdivisions, whether they'd sued or not, that could then negotiate as a group with the defendants. And if the lawyers for the negotiation class reached a settlement with the defendant, then they'd put that deal to a vote among the class members, and it would only take effect if 75% of the class voted in favor of it. But it would bind all of the class members, even the ones who voted against it. There are some not so coincidental similarities to the bankruptcy process that Professor Levitin described this morning. So while I was a huge fan of the negotiation class because it brought a lot of transparency and judicial oversight to the settlement process, but the Sixth Circuit Court of Appeals was not a fan and decertified the class. The defendants and the state AGs didn't really like it very much either because it ended up giving a lot of negotiating leverage to the cities and counties. And so instead, we ended up with the nationwide non-class settlements with the distributors and with Johnson & Johnson. So I'm going to talk just a little bit about some of the features of these settlements that are designed to ensure participation in the deal by enough plaintiffs, both states and subdivisions, that the defendants are willing to go along with them. So first, we have what's known as a walkaway provision. So these things are ubiquitous in mass settlements. And basically what they do is they guarantee the defendant at least a certain amount of peace, or else it can blow up the deal. So sometimes the settlement would include a certain participation threshold. So for example, if 95% of the plaintiffs don't sign on, the defendant can walk away. Other times there's no specific threshold, but the settlement gives the defendant an option to terminate the settlement if it determines in its sole discretion that too few plaintiffs have signed on by a certain deadline. And that's what we had here in the opioid settlements. So there were two stages, as I'm sure all of you know. At the first stage, the defendant got to determine whether a critical mass of states had signed on. And on September 4th, they said yes when 42 states agreed. And the second stage is for the subdivisions. And so the defendants will have to decide in January whether enough subdivisions have signed on. And if not, then they can terminate the whole settlement at that point. So walkaway provisions are one way to ensure a sufficient level of participation. A second settlement feature that's designed to encourage participation at the state level is what's known as a most favored nations clause. And the way this works is that the defendants agree that if they settle with a state that opts out on terms that are more favorable than the global deal, then they'll increase the payments to all the states in the global deal to match that. So the most favored nation clause essentially reassures participating states that no one is going to get a better deal outside of the settlement. But it's probably more important for the signal that it sends to non-participating states. So you could think of it like Dr. Strangelove's doomsday machine. It's designed never to be triggered. So having to top up all the states in the global settlement would be so catastrophically expensive for the defendants that they can't possibly afford to settle on more favorable terms with other states. So the defendants are credibly committing to fight future litigation by states tooth and nail. It's worth noting that there is no most favored nation clause for the non-settling subdivisions. So it's a state level thing only, but the settlements have other tools to encourage subdivisions to participate. So a third way that settlements can try to drive participation is through participation bonuses. So that is escalating payments as the level of participation goes up. And we've seen this in several mass settlements, I think most notably the World Trade Center disaster site litigation. These sorts of bonus payments are a major feature of the settlement here. So incentive payments based on participation make up almost half the value of the opioid settlements, $10.6 billion. These participation bonuses are standard in some ways, but they're actually quite unique in others. So settlements in general are fundamentally products of consent. So litigants aren't bound unless they agree to the settlement. Most of the time, even a class action settlement only lets you change the default rule to participation, right? So class members who don't want to settle can still opt out. And typically when a class action settlement is not possible, parties are only bound if they affirmatively opt into the deal. So the settlement designers have to rely on the lawyers who represent groups of plaintiffs to try to cajole their clients into settlement. And bonus payments are a way to sweeten the pot and make that sales pitch easier. But states are special. So states have a tool that's not ordinarily available in private litigation. States can pass legislation to cram down the settlement over the objection of subdivisions that would prefer to keep litigating. And they can pass legislation to bar non-litigating subdivisions from bringing future claims. And the opioid settlement encourages states to do just that and actually reserves the highest incentive payments for states that manage to bar all future litigation by their subdivisions, either through legislation or through a statewide class action settlement, or by obtaining releases from every subdivision in the state. If states don't use this sort of cram down to force all subdivisions on board, they can still get incentive payments based on how many subdivisions end up participating in the settlement. And these bonus payments escalate based on the number of litigating and non-litigating subdivisions that sign on to the settlement. So the closer you get to 100%, the bigger the jumps in the incentive payments. So if you can drive participation with bonus payments, you could also do the flip side, right? You can impose penalties or deductions for lower levels of participation. And the opioid settlements do that too, through suspensions and offsets for litigation by non-settling subdivisions. So if one of the tens of thousands of subdivisions that haven't yet sued decides not to take the settlement and then goes on to file a lawsuit, a portion of the settlement payments earmarked for that state are suspended, and then they're placed into escrow. And if that subdivision wins its litigation, then a portion of the money that the defendant has to pay out in court to the subdivision will be offset by a reduced payment in the global settlement. This is all complicated by a system of caps and tiers that really aren't worth getting into right now. But the upshot is that if the subdivisions bring litigation after the settlement, a portion of the damages that the defendants have to pay them are going to come out of the global settlement. So again, more participation equals more money. But I want to finish with another feature of these suspensions and offsets that's a little less obvious, but I think also probably more important. So remember, I said that one of the defendant's greatest fears is that the lawyers for the plaintiff will take the money that they made in early settlements and then invest that in developing and litigating new claims on behalf of new plaintiffs. So what the defendants would really like is to get the lawyers out of the business of suing opioid defendants altogether. The simplest way to do that would be for the defendants to just pay the plaintiff's lawyers to agree not to bring future suits. But the legal ethics rules don't allow lawyers to enter into agreements that restrict their practice of law. So as a general matter, plaintiffs' lawyers can't agree not to file future claims or not to advertise for future clients without running afoul of the legal ethics rules. Sometimes settlements require plaintiffs' lawyers to affirm that they have no present intention of bringing future claims or advertising for future clients. But those provisions are essentially toothless, right? The lawyer might not have any present intention of doing so, but those intentions could change the day after the settlement is consummated. The opioid settlement has a very creative way to get settling plaintiffs' lawyers out of the business of bringing future claims against the defendants. So because the settlement payments will be distributed over an 18-year period, and because the filing of new litigation by new subdivisions reduces the payments that go to the settling subdivisions, if a lawyer who represents a settling subdivision wants to take on a new client and bring a new lawsuit, that would create a conflict of interest, right? New litigation on behalf of the new client would reduce the settlement payments that are going to current clients, at least for the 18 years that it's going to take to implement the settlement. So the parties in the MDL actually went out and got an ethics opinion from a pair of law professors that spells all of this out. And the ethics opinion makes it clear that the conflict of interest would prevent settling lawyers from representing future litigants or advertising for future clients. So this effectively uses the conflict of interest rules to get the private lawyers who are currently representing the cities and counties out of the business of suing at least these opioid defendants. It's sort of reminiscent of a strategy that mass tort defendants have used in the past of trying to conflict the plaintiffs' lawyers out by hiring them as consultants for the defense on the settlement implementation. But it also gets around some of the ethical concerns that courts and bar associations have raised with that strategy of plaintiffs' lawyers essentially working for the defendant. Of course, the conflict of interest doesn't stop other lawyers from representing subdivisions that want to sue later. But it does get the lawyers with the most experience and the most already invested in the litigation, so the major players here, it gets them off the field. The ethics opinion also says that it would be a conflict of interest for a settling lawyer to take a referral fee for sending a new subdivision to another lawyer to file it. So the settlement also disrupts the referral market by taking away any incentive for the most knowledgeable lawyers to help non-settling subdivisions find new representation. So together, these provisions operate as kind of a partial substitute for the negotiation class. So they're not aimed at driving participation by subdivisions that have sued already, right? So those subdivisions can decide to settle or decide to continue to litigate with their current lawyers. Instead, like the negotiation class, these settlement provisions are aimed at deterring new lawsuits by non-litigating localities, and thus driving more claims into the global settlement. Okay, so there's lots more I could say about these deals, but I think I'll just leave it at that. So thank you.
Thank you so much, Professor Rave. Next up, we have Michael Barnes. He's the chairman of the Center for U.S. Policy, a not-for-profit organization that advances solutions to some of our nation's most pressing challenges, including opioid and other substance misuse. Mr. Barnes today will discuss the model law, as well as the levers of government and what's going on at the national level. I'll turn it over to Mr. Barnes.
Thank you, and good afternoon. I'd like to thank Georgetown Law and the Summit co-sponsors for the opportunity to participate. As we heard, I'll be discussing the Model Opioid Litigation Proceeds Act. And I do want to thank Shelley Weisman and her colleagues at the O'Neill Institute, as well as Susan Weinstein and colleagues at LAPA, and John Tariella and colleagues at Brown and Weinraub. This is the core work group that has developed the Model Act. We were also fortunate to have about a dozen reviewers who provided very helpful feedback on not just one, but two drafts of the Model Act. And the reviewers are acknowledged in the draft and will be acknowledged in the final version of the Model Opioid Litigation Proceeds Act. We would like to thank them once again. Each of them provided very, very helpful input that is actually visible in the work product. Our drafting process entailed reviewing and building upon the excellent work of our colleagues, including the Johns Hopkins Guiding Principles and state-level research by Shatterproof. We'll hear from Shatterproof next. We also participated in the ONDCP meeting to discuss the opioid litigation proceeds. As part of this process, we researched laws and bills in all 50 states and DC. We analyzed the settlement agreements and identified priorities. So briefly, I would like to highlight 6 core priorities reflected in the Model Opioid Litigation Proceeds Act. These are not the only priorities, but they are 6 important ones. And the first is creating a fund to separate the opioid litigation proceeds from the general budget, as we've heard many times today. And this is to ensure that we do not replicate the litigation model from the tobacco settlements. The second priority is supplementing and not supplanting existing funding. So making sure that we are getting extra and doing more. Third priority is dedicating the funds toward evidence-based and evidence-informed substance use disorder prevention, treatment, harm reduction, and recovery infrastructure, including bricks and mortar, based on our discussion earlier today that was of interest, programs, services, supports, and resources. So when I heard the question about whether or not the proceeds could be utilized to build a morgue, like we heard about from Brandon George earlier today, I immediately grabbed my copy of the Model Act and did a quick analysis of whether there could be any reasonable interpretation, any credible interpretation that this language in the Model Act could enable for there to be morgue construction as a part of the spending of these proceeds. And I do not believe that there is any credible interpretation of the Model Act that could allow more construction to fall under the infrastructure that's required for substance use disorder prevention, treatment, harm reduction, and recovery. So relief there. The Model Act's definition of prevention, I want to note, expressly does incorporate individualized healthcare and the safe prescribing of controlled medications. And so that, of course, includes opioids for pain and opioids for opioid use disorder. And this provision reflects the input that we received from the reviewers who said, wait a second, we have to make sure that our responses to the issues of opioid use disorder and overdose and deaths don't go too far, that these are not knee-jerk reactions and that they don't push too far to reduce access to opioids for opioid use disorder and for pain. And really that has occurred in many regards. And so this language under prevention is intended to make it clear that efforts to encourage individualized healthcare and the safe prescribing of controlled medications, including opioids or other controlled substances like benzodiazepines or sleep medications, insomnia, or other controlled medications, including stimulants, that these practices, these efforts to ensure safe prescribing do fall under the definition of prevention. A fourth priority is empowering a council to make spending priorities and decisions. And under the Model Act, the council members are qualified by professional experience in the substance use disorder field, expressly including harm reduction under that language, personal experience with addiction and recovery, including the survivors of decedents who are victims of this crisis of opioid use disorder and overdoses. And then to improve equity, the council is inclusive of communities that are disproportionately affected by substance use, as well as disparities in access to healthcare or disparities in outcomes. The council also will ensure that there is representation among geographic regions within a state and racial and ethnic diversity. A fifth priority is transparency. Where is the money going? What is the evidence of its effectiveness in saving lives? And I agree with Robert Kent and Professor Brandt that the politicization of opioid litigation proceeds spending is inevitable, but I do believe that transparency supports greater accountability through the political process. A sixth priority is addressing all substance use disorders, not just opioid use disorder. We've seen to date that settlement agreements that we've reviewed are limiting the use of opioid proceeds to addressing opioid use disorder and then co-occurring substance use and mental health disorders. And so what we've seen in current agreements is that there is a limitation to the actual substance that is the primary substance as part of one's disorder, and it must be opioid use disorder. Then you can get to co-occurring substance use and mental health disorders. But in light of the prevalence of polysubstance use, which we know from credible literature is the norm among people who use drugs, as well as the progression of substance use disorders, a substance-specific limitation on proceeds is ill-advised. And support for addressing all substance use disorders has been unanimous among our core work group, as well as the reviewers. From a legal perspective, if we think about how to move forward to avoid conflict and more litigation around the spending of the opioid litigation proceeds, for example, we heard earlier today that if a legislature just defies the language of a settlement agreement, that a defendant could go back to court and say, we're withholding these proceeds until they comply with the terms of the settlement agreement, right? To avoid all of that, we can expect that any decision maker on the use of these funds should reasonably and rationally be expected to follow the more stringent rules as between state law, which might be either completely silent on the question, or it might have a model, it might have an Opioid Litigation Proceeds Act, right? And the settlement agreement. So if you've got those two bodies that govern a particular set of opioid litigation proceeds in the fund, you're going to go with the more stringent rules so as not to break the rules of the other, right? So that what that means is if these agreements are final and are not withdrawn, as we heard about previously, could occur based on the negotiations, that if they do actually become final, then these existing substance-specific restrictions on the use of these litigation proceeds from these particular defendants and settling parties are certain to be followed, right? And so there would be a part of these pots of money that we expect in the states that would be limited to opioid use disorder and then the co-occurring disorders as well. And so for that reason, among many others, state legislatures should enact or amend their current laws to incorporate the recommendations that we have set forth in the Model Act. And that includes the consensus-based priorities around spending to address all substance use, and the other 5 priorities that we've discussed just in the past few minutes. And these approaches will optimize the impacts of the opioid litigation proceeds to their maximum public health and personal benefit. So once those provisions are given the force of state law, the priorities in future settlements or judgments can be drafted to match the state law, right? So ensuring consistency between state law and the settlement agreements will improve certainty as well as the efficiency in the proceeds spending. I look forward to our discussion, and once again, want to thank our summit organizers.
Thank you so much, Mr. Barnes. Really appreciate that. Last but certainly not least on our panel today is Courtney Hunter. She's Vice President of State Policy at Shatterproof. In this role, Vice President Hunter is responsible for engaging state policymakers to eliminate barriers to addiction treatment access and increase training and education of healthcare professionals. Today, she's going to talk about the world of state legislation, how the states are responding and setting up structures for when the settlement does occur. Vice President Hunter, I will turn it over to you.
Vice President Hunter sounds like Vice President Harris. Thank you. You've just elevated me to a very high elected position. Nice to be with everybody today. And as Professor Oliva said, I'm Vice President of State Policy at Shatterproof. And we've really been working with the folks at Johns Hopkins, my colleague Josh Rising, who's on the call today as well, on enacting these set of core guiding principles in states. And so as we really think about what are the tools and innovations at the state level to enact these settlements and protect these dollars, we've come up with a set of core indicators. And I know Dr. Rising is going to speak a little bit more about that tomorrow. But in our work, we're really having these conversations with attorneys general's offices and governor's offices. And some are saying to us, why do we need legislation? We have these approved uses within the settlement agreement. And we're saying that's wonderful, but it's not enough. And we really need to double down at the state level to protect these dollars. I think, something that also hasn't been mentioned today about the need to protect these dollars is they're inclusive of not just one settlement agreement, but of multiple. So not just the distributors in the MDL that we're seeing in the master settlement agreement or the Purdue settlement, but the McKinsey settlement and, potentially so many other pharmacies and distributors and manufacturers, Endo and Allergan, and the list goes on, that will be inclusive and be included in that bucket. And so we want to have a holistic and long-standing picture of what that looks like and how that's distributed within the state. In addition to the state laws, and actually before I go on, I'm just going to share my screen if I'm allowed. Hold on one second, sorry. Just share my screen here if you can all see this. This is just a state or state by state snapshot of where there already are dedicated funds. And there are about 20 states that have enacted dedicated funds. And I just wanted to give everyone sort of a snapshot of this. There are 13 of these states that had just enacted these dedicated funds in the last year. So states are really thinking about how do we prepare in our state to protect these dollars? We know that the first MDL funds, when the counties sign on, will start to be distributed in April or early 2022. And so they're starting to lay the groundwork, which is really important. But also not all dedicated funds are equal. There are some states that have just created a fund, which is great, but also not enough. And as Mike Barnes was just saying, the supplemental language and making sure that we're supplementing existing programs and not supplanting funding from SOR dollars and other funds that are coming into the states, existing programs, is critical. And there's only about 5 states of these 20 that have that supplementation language. So all the more reason to enact these bills at the state level. I will stop share. If anybody's interested in this, I'd be happy to share it afterward. And I think, in addition to the state laws, what we are seeing is the cooperation between counties and cities, localities, and the state. A lot of these dollars will bypass the state entirely and go from a defendant directly to counties. And so we want to make sure that the counties are working with the states, that we have some sort of assessment and evidence-based protocol, right? And that we're sort of all working together. And so as we think about not only oversight and accountability in the years where these settlements will go down, but what are the tools and innovations that we can have around assessment and continual assessment, needs assessment at the state level, so that we're meeting the need, we're meeting people where they are, but every state's going to be different, and we'll need that flexibility. And they know what's best for their states. So how do we help them with sort of the templates and those tools around working with the state working with the counties, and making sure that there's some sort of point person, right, to coordinate all of this, or multiple point people at the states. And some of the states have those, and some do not. And I think, in addition to the evaluation and needs assessment, in terms of these tools at the state level, we're really putting an emphasis on evidence-based programs, evidence-informed programs, and as Rob Kent said before, looking at what's working but might not be supplied or allowable under federal dollars, like fentanyl test strips, syringes, although fentanyl test strips are allowed now. But syringe service programs, we know that there's a great deal of evidence that's more than promising that these work to save lives. And so how do we allow for those purchasing of those, distribution of those, and have a larger plan, and share that information with counties, and also share information across counties and what's working within police departments and emergency rooms, and sort of give sample budgets for those local officials who are really going to be doing this work day in and day out. The state and local enactment of all of this is really where the rubber meets the road. And so it's wonderful to have, settlement agreements with the right language and allowable uses. But the ongoing oversight and enactment of that is going to happen day to day with our local officials. And so there's a real need for local and state advocacy around that, and also continual oversight and accountability as we move forward. So another tool or innovative thing to think about is sharing what the tracking and reporting is for each state, and even deeper down, what are the outcomes of that spending? So okay, great, you spent X amount on medication assisted treatment, but what was the outcome of that? Where did it go? And how is that working also on sort of the larger regulatory framework within the state? So I will pause there. That was just a lot of information. I want to leave time for questions. So thank you.
Thank you so much. Vice President, do you mind if I start with a question for you? Since you went last, so we'll kind of work our way
Vice President Hunter. You can
VP.
get whatever you like.
You and I have had a short discussion about this before, but some of the states' draft legislation or MOUs don't specify anything beyond the default on allocation or don't make express allocation formulas. And we know there's a default one in the agreement. How can states balance the spending and distribution of settlement funds across counties and cities?
Yeah, it's a great question, and something that I think we really want to think about with regard to state and county distribution. First and foremost is let's not look at retroactive spending. And there is, some allowable, I think it's 15% in the MSA around, retroactive spending and really reimbursement for abatement costs. That is not going to propel us forward. And I think it will also, take away from our opportunity to invest in what's going to save lives now. And so I would urge states to think about proactive spending and not retroactive spending, and supplemental, in addition to the programs that are coming in. With regard to county distribution, I think this is really going to depend on each state, and they need to take a look at what the needs assessment is, what's the evaluation, what's the makeup, what is currently being allocated to cities and counties, and how does that differ from the need. And I think Colorado is a good example of this. They're spending a great deal, I think 90%. On the counties. And in addition to that, we want to make sure that we're balancing the need for infrastructure investment, and that we're not just pouring money into a system that we know has tremendous barriers and is broken. We want to be innovating and making sure that we're bringing addiction into the medical mainstream. And so what are those opportunities, whether it's a faculty position for addiction medicine at a state, medical school, maybe that could create, more demand for medical education of addiction within medical schools and within residency programs. So we want to be forward looking. We want to do a needs assessment and look at what's already going on in the state and evaluate from there. And I think that, the folks that work on the local level have a really good sense of that. It's just about coordinating and making sure that everyone's listening and talking to each other at the state level.
Do any of the other panelists want to weigh in on this tough question about the distribution issue? Wait and see. Okay, well, my next question is for Dr. Brandt, and the question I have for you is, are there strategies for assuring that political leaders respond to the advocates who are advocating for individuals who have substance use disorder?
I think that there are, and as I look back at the MSA, it seemed to me that no one was really watching carefully, and there wasn't adequate activism and advocacy about what was happening to the funds. So a lot of the funds were squandered early on. And one of the things I'm suggesting is that attention, dedicated advocacy, a much closer relationship to media, news media and social media, so that the notion of accountability will be tied to the politics and the attention and education around the use of these funds. And I think that, it's not a perfect system for assuring that the funds are used appropriately, but the more attention it gets and the more activism. I was really impressed with Nan Golden's group, their ability to get the Sackler name off the Louvre. And I think a lot of us would have said, well, that's not going to happen. But, or when she went to the Guggenheim and tossed prescriptions over the circular staircase there. And, I've just been impressed. We all know that one of the most effective advocacy experiences historically was AIDS activism in the 80s and the 90s. And so I'm a big supporter of the kind of activism that will call to account legislators and mayors, governors, attorneys generals to make sure that the monies are spent in ways that really are valuable and appropriate.
Does anyone, I'm going to give everybody a chance to weigh in on any of these questions. So I didn't know. Professor Rave.
I'll jump in on that. So I think that's a really interesting and important point, right? Activism is very important in getting the money where it needs to go and making sure that attention is brought to all of these issues. But I think one other element that's maybe different in this litigation and this resolution, again from tobacco, is probably the presence of private lawyers, because more and you know there's lawyers are never the most popular people in the room, right? Because they're getting a lot of money and they make things difficult, and they write really long settlement agreements that are really difficult to parse. But they also acted as kind of a counterweight to the state level political apparatus, and I think really forced everyone to get more stakeholders on board as a condition of even getting off the ground with these settlements. And so, you know, that's not going to answer the hard question of where the money goes, but it is, I think, one factor preventing all of the money from just going to the state's general fund.
Just add one additional point that it's interesting to think about whether in the medium to long term, if there is a need actually to revert to the courts for enforcement of a settlement agreement. Say, for example, a legislature takes the money and puts it toward building morgues, and a governor signs that bill into law, right? Would the advocacy community, which of course naturally is highly emotional over this issue and oftentimes unwilling to even think about any sort of communications or coordination with the defendants, would they be willing to go back and advocate to them to return to court or to withdraw and withhold the money in order to ensure that what is in the settlement agreement is actually implemented at the state level?
Thank you. I'm glad you're, Mr. Barnes. My next question is, we'll start with you, and again, give everybody a chance to weigh in. And I really, this is a question near and dear to my heart, something I've been concerned about too. How does the Model Act help ensure that people with pain can get access to opioid medications when it's medically necessary?
We've opened the door through the language in the Model Act under the definition of prevention to enable a state or a council in a state to be able to approve funding that would be utilized to provide training or provide other sorts of services around the concept of individualized healthcare as it relates to the conditions that are treated with controlled medications. So that, of course, includes pain, opioid use disorder, ADHD, anxiety. And so it's available, but it's not exactly express, right? And so we have received feedback from some of the reviewers who are concerned that without the express reference to the ability to include integrative pain care, for example, there might not be a willingness on the part of the councils or whoever is controlling the money, maybe the AG, to approve it for its expenditure to ensure that the medical needs of people with pain or other conditions that require controlled medications are actually met. And so I do think that the group that is continuing to revise and update, and we've got one more round of edits on this Model Act, we are open to feedback. And so if this is something that the participants in this session believe should be expressed in the Model Act, you could send it back to LAPA and the O'Neill Institute and the other drafters of the Model Act and suggest it, because to date, what I've seen is the group has been very willing to find a consensus approach to pretty much every recommendation that's come through. And so I'm hopeful that, regardless of whether or not it is expressed in a Model Act or is expressed in a state's law, that the definition of prevention will be broad enough to allow it, so that if there are experts that wind up on the council, as should be, the way that we've designed it in the Model Act, it will be people who know this field, that they would be able to make the decision to approve funding to support access to individualized healthcare.
Thank you, and thanks for raising that really important issue. Professor Rave, we have a question for you from the audience, and that question is, the questioner asks, we have heard a couple references today to provisions in the settlements that allow defendants to reduce future payments if state local governments don't use the money per the agreements. Is that a pretty universal provision in all of the settlements we're seeing? And who gets to say whether the money is being used appropriately? The courts?
So that's a terrific question, and I wish we still had Paul Geller or Marcellus with us, because I'm sure they could answer it far better than I could, because they're steeped in this, and I am not. So my understanding is that yes, the settlements do say that, and they're pretty clear about saying that at least 85% of the funds have to go to abatement and to the list of approved uses. In terms of enforcement, my understanding, and I'm not 100% on this, is that it would go first to the kind of dispute resolution system in the settlement agreement itself, which would then ultimately be supervised by the courts. In terms of interpreting exactly what counts as abatement, I'm not sure how that would be interpreted, whether it would be broadly or narrowly. There's probably a lot of different factors at play there.
I think this is also, if I may, dependent on whether or not the state and the county share how they're spending the money, whether or not it is in a dedicated fund, and whether or not there is oversight or, councils at the state level who are monitoring this. There might not even be opportunity for a dispute if those guardrails are not put in place, because the public will not know largely how the dollars are being spent, and whether or not they can judge if that's appropriate.
Well, you had mentioned earlier in your talk a lot about assessing, progress here, right? And so what kinds of things would you suggest to the audience or the advocates here, work they can do in their states to ensure that there's fair and equitable assessment rubrics or things like that at either the state or the local level, and so far as treatment providers are concerned?
Yeah, I think the bare minimum is establish a dedicated fund for the states that have not enacted legislation. Enact the LAFA model bill, which is something we've talked a lot about. I think we need some sort of, in terms of tools, as we're talking about distribution, I think we need some sort of model MOU, maybe also for the AGs to have with the counties, in addition to legislation, to look at that distribution of funding and assessment that's taking place, and really oversight at the county and city level, which is needed in addition to the state level. There was over 2,000 localities, right? And political subdivisions, might even be more than that sued independently, that will be getting funds in addition to the states. So there's a tremendous need for oversight. And I think also having the reporting mechanism within the legislation, which I believe is in the model bill, right, Mike? The councils as well. So we're getting, diverse input, and that the councils can really be responsible at the end of the day for the year-to-year oversight. I think that to Dr. Brandt's point, there's going to be some sort of amnesia with this. People's memories are short, and if it doesn't continue to stay in the limelight in 6-7 years from now, it might be easier to misuse those funds, and so there's going to be a need for continued advocacy, and hopefully those boards can provide that, but there's a lot of states that don't have those in place right now.
I just want to add that Courtney's exactly right, and I like the idea of the model settlement agreement as well. But in the meantime, I do think that what we have in the Model Act can be very useful, not just with legislators at the local and state levels, but I think that this document could also be sent to the governor's office and say, look, don't sign a bill that doesn't have these provisions. It can be sent to the AG and say, look, don't approve a settlement agreement that doesn't have these provisions. So what we've got right now is enough to begin advocacy, and I believe it should start as soon as as soon as we can, if it hasn't already.
Mr. Barnes, let me ask you a follow-up question. Does the Model Act allow funding to go to smaller evidence-based organizations that don't receive federal or state substance use grant funding as things currently stand?
The Model Act is intended to supplement and not supplant. And so the way that I read that is that you have new people doing new things in addition to the same people doing new things. And that would naturally include bringing more people into the fold. And so the Model Act is written in a way that allows for the monies to go to not-for-profit organizations and government entities. Just as an aside, either of those entities, of course, could use the funds and contract with a private entity. So they're not locked out. But there's no mandatory size or budget requirement for a not-for-profit organization in the Model Act. And there's nothing that says it needs to be traditional or conventional state level or federal grantees. And so it ultimately, if the Model Act were implemented, it would go to the council. And the council is structured in a way that it does have representation of people who know their communities and they know which organizations are on the ground and actually making a difference. Additionally, there's the evidence-based services and programs and supports and all of those options that are set forth in the Model Act, but also there's the evidence-informed. And some of the more nimble, some of the newer organizations that really have a compelling case for funds, perhaps to develop the evidence base around a particular intervention, they would be permitted so long as the council sees the benefit and is willing to take that risk on them. And the good thing is that we have had the input and developed the Model Act to include the input of making sure that the performance measures are set forth and required. And then of course the reporting is required as well to show the exact impact that these funds are having through the organizations to which they're distributed.
Thank you so much. I'm out of questions, but I will turn it over to the panelists. Do any of you want to take the privilege of asking the rest of the panelists a question, something that's hot burning on your mind after this stimulating discussion?
My mind is full. It's been a productive day.
I was just going to congratulate all of my fellow panelists. I think we were the only panel to go short, which is so appreciated. I do have a question though, and this comes from a lot of family advocates and folks that we work with on the ground. Is there a way through, future settlements, and I don't think we've broached this today, where, the liability and the defendants can actually admit wrongdoing and settle? Is that possible? I'm sort of looking to the lawyers on the panel.
So I'll take a stab at that. So there's nothing that would stop that legally. It's just I can't imagine a defendant who would agree to that, right? If they're going to settle, they have to get something out of it, and usually what they're getting out of it is that an end to the litigation without admitting liability. Like that's the big thing for them. So settlement is not really a good tool for that kind of sort of, it's not procedural justice, it's sort of like retributive justice. You want someone to admit the wrongdoing. It's not going to come formally in a big settlement like that. I mean, sometimes in smaller cases you can get that. You can get some sort of resolution if you have two real people coming together in a mediation and they agree on a settlement that involves an apology. But it's hard for me to imagine a big corporation saying, "Yeah, you're right. We're sorry."
I think, where my impetus for that question comes from is how do we prevent this happening again, right? And we saw Altria and the tobacco companies invest in vaping products and really use the same sort of marketing playbook to young people. And so I don't want us to be sitting here in another 20 years having this conversation. And by admitting wrongdoing, is there a way to, through regulation, or I don't know, I'm just throwing it out there, prevent them from, using funds to invest in other addictive products?
VP, it looks like you've triggered All-Star Law Professor Maria Glover, who has her hand up. So I'm going to call on her.
I wanted to not just echo what Teddy said, but I wanted to build off something that Ariella mentioned earlier. She said, look, settlement isn't the only way these things can resolve. Sometimes they're trial. Let me be clear about what sometime is. It's 1% to 2%. There's this famous saying that only a fool or fanatic goes to trial. And there are tons of reasons for that. And admitting wrongdoing and obtaining global peace isn't just what defendants get out of the deal, as Teddy said. It's also deeply connected with insurance companies, right? So there are various levels of insurance coverage that vary and change depending on whether and to what extent particular defendants did or did not admit liability. And of course, there's tons of complexity in that, and there's tons of variation in that. But so it's not just an incentives matter, although it is very much an incentives matter. It's also a matter of sort of behavioral and rational litigation economics, namely that almost no one goes to trial for any number of reasons. And it's a matter of sort of the insurance structure of corporations, that getting to full admitting of liability is not going to be great from an insurance perspective. So if what you're trying to do, and I hear this from the emotionality of this crisis, is we don't want to be here again in 20 years. I'm not sure as a practical matter, but as another matter at all, that admitting liability is going to be the way to prevent us from getting there. I think that we have to take a hard look, not just as to how we respond to this crisis ex post with the settlements, but how we think ex ante in terms of regulatory apparatus and structure going forward for products liability, for mass harm, how we structure into settlements, even if they don't admit liability, that it's hitting companies sort of where it hurts, right? It doesn't hurt Purdue, but if you get Sackler money, then you're in Tom Baker blood money arena. So I just wanted to add additional context to what Teddy said, that not only would you not get defendants to agree to that, but it is not as if there's a wide statistical reality of alternative to take these things to trial or to buck up against the insurance apparatus for these companies. So preventing these sorts of things from happening again is, of course, critical. I think we just have to think differently than sort of that, poetic justice, retributive justice, admission of liability. That's going to be difficult in a lot of cases to get.
Well, in the case of Purdue, of course, it's disappearing or restructuring as a B Corp. So if it ever has any profits, presumably they will be distributed in the public interest, if that's a correct understanding. So Purdue, as we know it, won't ever do that again. So Courtney, that gets you there, at least as it relates to one of the defendants.
Yeah, and
that's not asking for me, just to clarify, but for, sort of this has been a sort of an underbelly issue, within the advocacy community. And I think it's worth, bringing up in the context of tools and guardrails.
I think to my point, though, that's a creative way of getting at it.
Yeah, it's one of those things that's just sort of a fundamental question of like, what is litigation for? And litigation can be for a lot of different things, but sometimes you have trade-offs among those values, right? So if you really want the hold someone accountable and have that retributive moment, that may cost you, right? You may not get as much money, or you may not get the money as fast. And you also have to factor in kind of the deterrent effect. So to take us back to Professor Campos this morning, right? If part of the purpose of litigation is to have sort of an ex post, it's like an ex post regulation to create a deterrent effect. What's more deterring, having to pay out $26 billion in settlement, or having someone take you to trial and maybe say, prove to a jury that you were wrong. It's a pretty good argument that for corporation, the $26 billion is going to be a little bit more of a motivating factor. But it's a constant balance with litigation, and one of the problems with trying to push societal problems like this into a litigation system that's really not designed to deal with them.
Thank you, Professor Rave, for closing us on that excellent note. We are right at time. Thank you, panelists. I really appreciate it. And Professor Glover, should I turn it back over to you?
Sorry, I was having a little bit of trouble with the unmute. I'm sorry. Thank you so much to that panel. And I think we did leave on such a good note about the goals, the priorities, the opportunities, and the limitations. And so I just wanted to wrap up with sort of an overarching summary of today, but perhaps more importantly, to give a roadmap for tomorrow, which is not just an add-on to today. It's where we take all of these insights and discussions and build it into how do we succeed? How do we ensure quality? How do we create models for the future? So by way of summary, the litigation situation, to put it mildly, is complicated. We have multi-district litigation, attempts at negotiation classes, we have individual claims, we have state and municipality claimants, we have bankruptcies, we sort of have, the kitchen sink, and the temporal stage of these are different. Some litigations and settlements are pretty much over. Some are ongoing, for good or for ill. As Paul Geller made clear, bellwethers and opioids may well do more harm than good in terms of delay at the very least, given that this is an ongoing and just devastatingly escalating crisis. Bankruptcies have begun. In some cases, they've concluded, although we know they're subject to numerous appeals. All eyes, in some ways, are on the opioid bankruptcies, as they could provide a roadmap, maybe for an additional tool to make the litigation system work for public health crises. The fear, though, is that these opioid bankruptcies will provide a clear roadmap for wrongdoers to dodge and limit liability. Litigation provides opportunities, it provides limitations. Litigation is perhaps not best suited to address large public health crises, but let's not be too harsh on either litigation or the lawyers who pursue it. The regulatory design of our country and longstanding history means that litigation will have to step in. At some level, someone has to do it, someone has to pay for it, and someone has to get paid. So it could be Congress getting paid with taxpayer money, but they repeatedly refuse. They refused on asbestos. They refuse on all number of products liability issues. They refused in opioids, and we've had to cajole them even when they did step in with 9/11 to continue funding payments to first responders. That was the Jon Stewart testimony in front of Congress. So it could be Congress, or it could be lawyers whose fees don't come from taxpayers so much as they come out of defendants' coffers. So there are opportunities. Litigation is a tool when other remedies have failed. Unlike tobacco, as Professor Brandt in his just fount of wisdom on this noted, we're having these important conversations now in September of 2021. with the ears of the key attorneys, with the ears of the key stakeholders, and just at the cusp of when state legislatures start going into session in the late fall and early winter to set budget and guardrail priorities. So we're not Monday morning quarterbacking here as a matter of time, and we're also not speaking in silos. We're not having a conference with just the attorneys and just the law professors and just the public health folks. No, we're having this conference now with this dynamic group of people. So whatever happens in all these settlements, I'm confident it will not be perfect. But after today, especially, there's reason for optimism that it'll be much better, at least than tobacco. There's a ton of innovation going on. This funding will fit in with all sorts of funding from federal and state government, which we have to work to align. And hopefully we have folks at the ready in the federal government, as we discussed, to facilitate this and manage and claw back funds if they're misspent as a matter of quality control. We're talking a lot and talked a lot today about stakeholder input, which is one of the biggest visions of this conference. It's critical to have an interactive and inclusive feedback loop among all the stakeholders, and to engage people, including those, and especially including those with lived experience, in a meaningful way. We talked about the Colorado model as one way to do that, but one size will not fit all. We talked about advisory councils. We talked some about how do we make sure that advisory councils are diverse and inclusive and appropriate for regional needs. We're going to continue to talk about tools of inclusivity and participation. Some of our priorities, we talked about funds for service and supports that currently are not funded but are critical: recovery support, recovery infrastructure, harm reduction, workforce, all with a lens toward equity inclusion, as well as evidence-based treatment. And beyond that, and this is another intersection of this sort of cross-cutting group, careful attention to the legal hurdles to providing evidence-based treatment that span beyond tort law and into family law, employment law, and countless other arenas. We talked about supplementation and supplantation for guiding spending. A state law, one of the focuses of this conference, is an important tool, and Mike just covered ways in which that could be used, even if it's not has the force of law. And it's one piece of the puzzle. Professor Brandt and others highlighted the importance of activism and advocacy, which I think has to be really emphasized, in as much as this litigation and this public health crisis is not an apolitical thing. This is politics. Politics pervades all of this, and advocacy and activism are critical to those political priorities. And as was mentioned earlier, I believe by Jen Oliva, keeping people's minds on this important issue. Perhaps the biggest theme, though, and it's probably already coming out, that I took away from today is participation. How? More education through the O'Neill Institute and others, intentionality and outreach by attorneys and advocates to key voices, perhaps requirements that certain key voices be present, continued conversation across arenas. The silos tend not to result in meaningful participation by key stakeholders. With this comes so many possibilities and so many potential pitfalls. And tomorrow is so critical for bringing that together, because tomorrow we synthesize all the information and insights from today in service of dynamic discussions on how we ensure success, quality, transparency, participation, all the things that every one of us said and discussed that we care about. It's all good for us to have wish lists, and we all have them. But how do we make this happen? Which ones can we make happen? How do we bring together the divergent and critical voices and the important effort, the village that will be required to direct and manage these funds appropriately, discourage wasteful spending, and with all hope, help abate the epidemic? Tomorrow we'll also talk about what we can learn and what we can offer to the future. So today we talked a lot about the mistakes of the past, but what can we learn not just from those mistakes, but what we're starting to do better now, and apply those lessons not just in opioids, But with hard work and commitment from all these stakeholders, can we move toward a better model of public health management through litigation, a more inclusive model? That's our conclusion for tomorrow and built on the foundations of today. And I'm both excited and optimistic that we will come away with new, innovative, and insightful rubrics for the future. We'll also discuss tomorrow, just one last thing, a few, potential ideas for things that might come after the conference, in addition to model laws. I think that might be partly the focus of the visioning discussion tomorrow. But again, tomorrow's all about how do we go forward? How do we get opioids as right as we can, as inclusive as we can, as equitable as we can? And then how can we use what we're putting together here and within this community to create better models for the future here and abroad? I want to thank every participant, every invitee today. This conference was highly informative, highly thought-provoking, passionate, and interesting, engaged, dynamic, all the things and more that we could have wanted. I'm very much looking forward to seeing everyone tomorrow. I believe our fantastic tech team is going to send out links and reminders for tomorrow, which will begin, at 8:30. So we'll begin at 8:30, but we will conclude by lunch. So thanks everyone for a fantastic day, and we look forward to seeing all of you tomorrow.